Okay, good morning, ladies and gentlemen. We will start our session after the presentation yesterday night by Judge Luca Perilli of the report on the judicial independence and access to justice in Turkey. Now we will have three witness statements in a row because you reorganized yesterday a little bit the schedule. So we have the three witnesses and then a comfort break. Okay, it's not a coffee break, a comfort break. And then the last report by Johan Vande Lanotte about crime against humanity. So that's the schedule for this morning, and this afternoon your video. Voilà. And then the session will be closed. So I will call first Mr. Faysal Sarıyıldız for his testimony. You have the floor.
You can hear me? Yes. Hello. First of all, I would like to relate my regards to all of you. My name is Faysal Sarıyıldız. In the year 2016, in Turkey, I was an MP from the HDP, People's Democratic Party, and I had to come to Europe. Since then, I have been residing in Europe. On my way here, I went through a serious shock and trauma because this happened in the 21st century. It's very recent, and this can actually be termed a war crime or a crime against humanity. I was born in Cizre, and I was elected as an MP from Cizre on the 14th December 2015 until 16th March 2016. For 79 days, there was a curfew process. So this was a curfew period. This was a very systematic process which was pre-planned, premeditated, and during those 79 days we had horrible experience. People were burned collectively. The city was burned to the ground. It was destroyed. Hundreds of thousands of people had to go on exile. So many crimes can be used to describe that situation. So I have been given 10 minutes. Within this period of 10 minutes, I will try to do my best to make this understandable for you. Honestly, I've been in Europe for about 5 or 6 years. I'm a bit angry. I'm furious because now we have the so-called progressive world. This is the hotspot of the so-called progressive civilized world. But when it comes to a war crime that happens elsewhere in the world, we don't have a power or a political power who has the will to intervene in such a place where there were crimes against humanity. Because when you have a war crime, it's a crime against the whole humanity. And when you cannot prevent it, as we can see right now, it spreads throughout the world. These crimes spread throughout the world. So in this process that I mentioned, 288 people whose names we currently have were massacred. Most of them were women and children. Of course, there were also youngsters and people from different age groups. Thousands of people were injured. But first and foremost, 120,000 people inhabiting that sub-province went through an unforgettable trauma. They will never forget this, because after the process that I mentioned finished, within the first couple of years, more than 15,000 people committed suicide in that sub-province. They are still under psychological treatment. They just couldn't overcome this trauma, or they attempted suicide and they still couldn't overcome this trauma. So on the 16th of December in 2015, the public officials in Cizre received this message. This was sent by the Ministry of National Education of Turkey to the teachers and public servants. There were thousands of public servants in Cizre, and the government asked them to leave. this city. Can you imagine? In a place of 120,000 people, the public officials were asked to leave the sub-province, and we noticed that this was an attempt at a massacre, so there was a plan to commit a massacre, and we immediately communicated this to the public opinion, because in Cizre we were chosen, our party had received 94.5% of all the votes in the previous election, so we were seen as a threat. And there was a process of non-conflict, so the conflict was interrupted during that period. There was a truce, and it enabled us to establish a culture of democracy, and this gave us a good chance to have good bonds with the people. But when the political government lost their power, they reinstated this concept by integrating with the pro-state actors. So in the year 2014, the Undersecretary of Public Security and the Chief of Staff and the government had laid out a plan in 2014, and this plan was later disclosed. So one day before these acts happened in Cizre, this had already become public in the news, and they had said that if necessary, 15,000 people could be killed and more than 200,000 people could be put in jail. And they were referencing the events that happened in Sri Lanka in 2010. So the report that I mentioned was published in the year 2019 in the state television of Egypt, and it consists of 45 pages, and you can access this report. It's open to public. So this actually was a premeditated event, so it has been confirmed. There was also a document, I will try to find it. So in that document, as you can see here, all the soldiers, so 10,000 soldiers and policemen who attended these operations had received special training, and they were told that they shouldn't be afraid of being brought to the justice or in front of public prosecutors. If there was a threat perception, even if there are civilians around, they could proceed with the destruction. And back then, this was already mentioned, before the violence in Cizre happened, this was already disclosed and it was made public in the press. And then in the year 2019 in Egypt, it turned out that this page was a part of this whole plan of destruction that I mentioned, which was broadcast in the Egyptian TV in 2019. I would like to make it very quick because I have very short time. So this message was sent, this SMS was sent to the people. Hundreds of thousands of people were living there. And then some vans were carried into the sub-province, were used to carry military artillery to the province. So this school started to be used as a station. Here you can see the vans which have military devices in them. Here you can see the state hospital in the sub-province. It was used as headquarters. You can see there were tanks and other armored police vehicles in its garden. And then throughout the city, as you can see, maybe you don't see it very well in the photos, but you can see at a distance of 15 to 20 meters, there were armored vehicles stationed at that place. So you can see it better here. If I could magnify this picture a bit more, you could understand it better. But so this is the downtown of Cizre. It's located in a pit or in a basin, and it's surrounded by mountains. As you can see, there is smoke rising from the ground. There is a tank there. We also have the video of this. This tank was used to hit downtown Cizre. There were 20,000 people inhabiting in this area. So every day, 2 or 3 people were killed during this 79 days, and most of the people were asked to leave the city because people were insisting in remaining in Cizre, and that was a political attitude. But when they also lost power and water, after the first 40 days, and after seeing that there were many casualties and injured people, a lot of them had to leave. There were a couple of youngsters, there were university students, there were also people from the civilian popular assembly, there were women, there were artists or people who were producing documentaries, and people insisted in staying in Cizre. They said that this was a political attitude and they said they would stay there as a shield to prevent a potential massacre. And they started to bomb the city with tanks, as you can see, smoke rising from this ground, and this was a result of attacks with tanks. After a while, this is what happened, dear colleagues. I had shared this on 22 January 2016, I believe, and then a group of people called me. I was 150 or 200 meters from the site that I mentioned, and there was an international Silk Road between us. It went through the downtown of the city. There were military vehicles stationed there. We tried to go there, but then they used machine guns against us. So 2 people lost, 15 or 20 people were injured. So we tried to save 40 people from there, but we haven't managed to save them all. We also have the videos, and you can see them later if you want. Then the Chief Commissioner of the United Nations, Mr. Al Hussein, mentioned that this was a horrible thing. They even used the metaphor to say apocalypse. This is an apocalypse. We need to immediately go there and perform an inspection. But Turkey rejected the arrival of the UN delegation, and nobody can still go there. So there was an increasing trend, and the government kept saying the following. After a while, the city was bombed down, and people took refuge in the basements of the buildings, and they were beaten up. They were subjected to machine gun fire. The injured people wanted to be taken to hospital. They said that this was their legal right. As per the legislations, we had connection with the TV. Also, they had connections with us. We wanted to broadcast their opinions live, but the political government headed by Erdogan had been saying with all the ministries, they say, this is disinformation, there are terrorists there, they need to be destroyed. There is a conflict there, and the people who die are terrorists. That's what they were saying. At that time, I connected some people who were staying there in the basement. They didn't have smartphones because they had no electricity. They were only using some batteries to charge their simple phones, non-smartphones. And then they mentioned these names, 8 or 9 of these people, such as İstanbul Kesir, Mehmet Yavuzaj, Ali Fırat Kalkan. All of them are university students. They went to Cizre to become human shields. These are people who were registered at a university at that year. We also have a person who is 13 years old, for example, at that time, Tahir Çiçek. We also have a person who was 65 years old. And I immediately wrote down the list of these people, saying that these are injured people. I shared the list with the government and with the press. I gave their address, and these are the people who are just exhausted but not injured. So I had this list, and for 1 week these people were held there. The government told us the following: if you go there, they will say everything happened by the book, everything happened by the law. So the ambulances were sent some to some place. They were said this was actually a mise en scène. That this was fake news. That's what the government tried to say. But I'm trying to show you what the ambulances did. This was a gas station at the entrance of Cizre. So normally only patients should be carried in these ambulances. This belongs to the Ministry of Health. But behind this, you see, there is a fuel tank of 4 or 5 tons, and it was filling in fuels in order to carry fuel to the tanks that were burning the city to the ground. So from the beginning till the end, this was horrible. This was totally illegal, and these practices can be termed crimes against humanity. And on the other hand, the government was exhibiting 3 or 4 ambulances, and they were claiming that they were helping the people. So let me explain to you my personal anecdote. On the 22nd of January, we were told that there were 4 or 5 injured people in the neighborhood, and we immediately applied the ECA charge with a precautionary measure application. We told them that these people had to immediately be taken to the hospital for treatment, but the government didn't allow us. They said this is a conflict zone, you cannot enter there. We went to those people. So I was escorted by 20 or 30 people. I went to that neighborhood, and there was a public servant who used to work at the municipality. There was also a university student, and there was also another person who was 55 years old, but they had died because they had lost a lot of blood. But in the meantime, there were also 7 or 8 people who were also injured. So we still have their records, and There is a cameraman who was always with me because he didn't have security of life. So with him, we went to a neighborhood and we took footage of everything because we knew that the government could have killed us and we knew the scale of the events. So they always mentioned that I was an MP who was trying to save the terrorists. There was a chauvinistic climate in Turkey. So once the government tells that about you, nobody believes you anymore. You are discredited.
The time is over for your testimony, and you will have opportunity to more elaborate in answering questions from the judges. So thank you so far, but now I have to stop your testimony.
O zaman ben sadece bir iki
Let me just wrap it up in a few minutes, please, if you allow me. I believe that I was a bit slow.
You have the opportunity in answering questions.
evet o insanların hepsi yakıldı.
So all of those people were burned there. They were burned in those basements. So this is a forensic scientist, Mrs. Shebnem, and there you can see they look at a skull. So this was a very young person of 11, 12 years old.
Much, sir.
Tamam,
Now it's over.
bitiriyorum. Yalnız anlattıklarım
There is still a lot I wanted to explain. I haven't had the chance to explain everything.
I have to do that in answering questions. Thank you very much. Now I will give the floor to the judges for any question. Judge Bianco, you will be.
Thank you, Madam President. Thank you for your testimony. You are referring to some appalling situations. However, my question is direct. What is the relevance of your testimony to the topic that we're discussing today, independence of the judiciary and access to justice? Do you have any kind of conclusion in that regard? Because that's the topic we are discussing.
So, could you please repeat again? I missed the beginning of your question because my interpretation equipment didn't work.
The crux of my question is, what is the relevance of your testimony for the topic that we are here to discuss today, namely the independence of the judiciary and access to justice? So if you can underline this element, please.
Yes, let me immediately respond. So, the perpetrators, so when the organizers of this event mentioned this to me, I immediately accepted this invitation. I said that I would talk about the crimes against humanity that happened in Turkey, and I told the organizers that this was a topic of global relevance, and that's how I prepared my presentation. So you can say the following, maybe I should put it this way, even though it's not fully related with this topic, I just wanted to find a platform to talk about these things. We need to make a note of these events. These are events of historical importance. So I don't know if my presentation hasn't been directly related to the particular topic or the headline of this session, but I believe that these are issues that we should all know about. So I also have a presentation. If you could give me 5 or 6 minutes, then I can finish my presentation, and I think it will be more clear.
No, good. Thank you very much for your testimony. I think we have heard what you have to say, and now we have to stop. Voilà, because all witnesses were allocated the same period of time. So, for the requirement of a fair trial. So, thank you very much for being with us. I think what you have said is important. Of course, it's not related to what we are discussing. No, it's over. I'm sorry. I'm sorry. Now it's 10:30. Thank you very much for being here, and I will call now the second witness, Mr. Hasan Dursun. No, I'm sorry. I do prefer to stop now, justice basis, okay?
Sayın Başkan, değerli mahkeme üyeleri, hepinizi
Yes, hello, dear President, dear members of the jury, of the dear judges. I'm very excited to be here with you today. And I would like to tell you all the facts. So I was condemned to 22 years in Turkey, and I didn't feel this excitement while I was waiting for my condemnation in Turkey, because I felt that this wasn't real. When I was in front of the judges in Turkey, I felt that this wasn't real, and I knew that they didn't have a real power. They didn't have a will to perpetrate me, because I felt relaxed in front of them. Already on the 15th of July, when I was taken under custody, the situation was very clear for me. I started working as a prosecutor in 2004. Between 2011 and 2014, I worked as a judge at the Judges' Council in Turkey. And later, of course, we had the corruption trials between 17th and 25th of December. And following this, the Erdogan government
ele geçirmek amacıyla özel
created a new law to change the role of the Judges' Council. And then they ended my role. And so all the personnel of the Supreme Board of Judges and Prosecutors were transferred, and I was sent to another city. And I realized how lucky I was when the coup started, because in 2014, if had the Erdogan government been behaving as arrogantly as they are today, then I would have been arrested and I would have been liquidated. But in 2014, I was able to start as a judge in Sivas. And on the 16th of July, after the coup, I was still a prosecutor in that morning. But later on that morning, I was taken under custody. So I was actually a successful prosecutor in Sivas because I had a master's degree and I had a doctorate. I know English quite well. I did lots of projects. I initiated many projects with the European Union agencies, and I worked within these projects. And I also published several articles in academic journals. And I also worked so that human rights could be advanced. I worked on many projects, on human rights projects. I'm not saying all this to brag, but because after the 16th of July, these were all used as evidence against me. Because the Judges and Prosecutors Council, when they liquidated me, and in their indictment against me, said that if any prosecutor or judge were working well, if they have never been subjected to a discipline investigation, if they had good relations with the people around them, if they had a master's or a doctorate, if they ever worked in foreign countries, and if they are a successful prosecutor or judge, beloved by everyone around, then according to the Council of Prosecutors and Judges, and also by the Supreme Court, the Court of Cassation, then you are seen as a terrorist. You're seen as someone who perpetrated the coup and as an enemy of the state. And of course, I was one of those people, and 5,000 other judges and prosecutors, such as myself, were forced to quit or were forced to retire. And they were purged. But if you don't have these qualities, or if having these qualities, you do not express these courageously and independently, then you can't continue to work within the current system, within the current judicial system. And we have been listening to different witnesses these past 4 days, and we've understood what type of justice system we're functioning inside in Turkey. And these injustices, we have learned about all these injustices, and maybe these existed all the time, but they were never perpetrated as arrogantly as they have been today. And today's government purged more than 5,000 judges and perpetrators. Yes, we had this failed coup on the 15th of July. Normally, when there is a coup, the army will pacify the other army members, which they see as enemies. But after the 15th of July, it's not army members or soldiers that were targeted, but other people, the community at large. And so it was judges and prosecutors who were purged, who had to be destroyed. And as Recep Tayyip Erdogan said, 15th of July was seen as a gift from God, and this was used as an excuse to purge all these people, to destroy all these people. And on the morning of 16th of July, while the coup was still ongoing, 245 judges and prosecutors were taken under custody. So the Ankara prosecution started an investigation on the 16th of July during the night, and the Judges and Prosecutors Council took a decision to purge the 245 prosecutors and judges, of which I was also a part. And they sent this document to the relevant prosecutors. There was no other file. There was only this one-page document. And they gave this order to the policemen. So the 2,745 prosecutors and judges must immediately be taken under custody. They must not be allowed to go outside of Turkey, and they must be arrested. And so, following this order, I was taken under custody, and the police officers and the police officers who arrested me, and the prosecutors and the judge who took a decision about me, I asked them, what is the evidence against me? And I had been working together with these people for 3 years in Sivas, and they confessed to me. They said, yes, we know you. You're a hardworking, successful prosecutor. But we received only this document and nothing else. But they said that later on they would send us bags full of documents, and we have to arrest you, and otherwise we'll be arrested ourselves. And this is all in my case files, because the judge could not look at me in the face, and I had to write my own indictment. Later on, I was sent to prison on the 20th of July, 2016. When I was sent to jail, I was, again, together with police officers who I'd worked with before, and he told me that he'd received certain orders and that 3 wards had been prepared for the judges and prosecutors who would be brought there. And so on the 16th of July, when I was taken under custody, it was already for sure that I was going to be arrested. This was all just a farce, a theater play. So I was in jail for 30 months following this. Around 13 months later, I received my indictment. But throughout these 13 months, I was never able to learn about the evidence against me because my file was kept secret. Normally, a confidentiality decision is made to protect the person involved. But finally, when I was able to read my file, I understood that actually this confidentiality had been agreed on to hide the fact that this file was empty, that there was no evidence. As everywhere else in the world, in Turkey as well, judges and prosecutors have to be judged, have to be investigated in a special way. You can't do this in a random way. There are special procedures surrounding this. However, the orders that came in made this not so. The judges and prosecutors who arrested me, who took me under custody, they went against these procedures. Throughout the procedure, I expressed my thoughts. I told them that this was not a legitimate court. But despite this, my demands were always cancelled. And they sentenced me to 7 years of aggravated imprisonment. And so orders were sent, and special personnel was sent to apply psychological pressure and physical torture. And I was physically tortured. My hair was long. They said that they wanted to cut my hair because when I had to go to court, they don't want us to be sympathetic to the public, and so some police officers came and cut my hair forcibly, despite my will. against my will. And I made some complaints against this, but they refuse it. And they opened a new court case against me because I acted against the police officers. Today, more than 1,000 judges and prosecutors are still in jail, and even more are now waiting to be imprisoned because their files have been sent to court. And they're, of course, seeking to flee Turkey. But unfortunately, in Greece and in the Aegean coast, my colleagues who have been trying to escape, who've been going to Greece and to the Greek islands, are, of course, being sent back into Turkey. This is very unfortunate. Yes, when I read Luca Perilli's report, I had to remember many details that I'd forgotten about. This report tells of my life better than I could tell it myself. I was very sad when I read this report because I believe that I would like to have a judicial system in Turkey where all the population is in security. This is what I always worked for. This was my ideal. I love my country and I love my people. And I'm still dreaming of a country where the judicial system will be fair and adequate. And this is what I'm still working for. But I had to leave my Turkey. Now I have my own YouTube channel. And I helped to create 2 new associations. In Turkey as well, I was a Yarsav member association member. But many of these members were imprisoned. And the president and members of the board are still in jail. So of course, I believe in the importance of NGOs when it comes to judicial system. But in Turkey, unfortunately, there is not a fair judicial system. Because when it comes to political cases, we see that the judges and prosecutors can't do as they like. They have no independence. I can give you another example. More than 1,000 judges and prosecutors have came against their had made many complaints against their cases, but they were told that if there is a political court, then there is nothing to be done. The courts can do nothing about this. And of course, I'm very disappointed about the European Court of Human Rights, and I'm very disappointed about what all the other European agencies, international agencies, did about all this. They never showed an immediate and effective reaction against this. But of course, I know how they work, so I know that this is normal. But there is a very widespread, systematic human rights violation going on here, and I would have expected the international community to have reacted more forcibly against this. Right now, the Court of Cassation and the State Council and the Constitutional Court, especially when it comes to political files, they've become certain state apparatuses that follow a certain procedure. They have canceled a 100-year judicial system and have started a new system. And they've started a new judicial system based on enmity. And now in Turkey, there are 2 types of human beings. One are those who are seen as good by the regime, and the other side that's seen as enemies of the regime. And if you're seen as an enemy of the regime, if the government sees you as such, in that case, the judges and the courts, unfortunately, do not live up to the responsibilities given to them by the laws because they're afraid themselves. We have to recognize their fear, because if they go against this system, they know what they will come against. They know what will happen to them. When they look at myself and more than 5,000 judges and prosecutors, we weren't only purged, all our diplomas were canceled. Our insurances were canceled. We're not able to get employment anywhere else in Turkey. And if we ever try to get employment, then the employer will be seen as a terrorist, as someone who supports a terrorist organization. And so in Turkey, there are 5,000 other judges and prosecutors such as me, and Turkey has become a kind of open prison for all of us, an open-air prison. Well, Luca Perilli's report went into all this in detail, so I will not repeat all this. But as a prosecutor, as the previous witness said, of course, the whole of the Turkish population is living through all of this. And we're faced with a judicial system, with members of the judicial system who cannot go outside of this regime, who cannot go outside of these procedures. And I know how the present judges and prosecutors are working right now, but right now we have to struggle for our country. And right now, the judges and prosecutors think that they're fighting for their country against terrorism. They think that they're working for their state. And they see everyone who's not working for the state as enemies. So when these 5,000 judges and prosecutors were purged, unfortunately, the opposition kept its silence, and they even supported this. So the opposition parties and the bars they all supported this and kept their silence. When I was arrested, none of the bars reacted to this. And they even threatened the lawyers who were prepared to defend us. They said that they would be punished if they would try to help us. And while I was in prison, I couldn't reach any lawyers. I couldn't reach any assistance because when I was with a lawyer, of course, they were being listened to. They were being videotaped. And later on, these were used as reasons to purge the lawyers who helped us. They were used as evidence to threaten them and to imprison them. Because if you have become an enemy of Erdogan, of the state, then you're no longer able to use any of the rights that have been given to you by the laws, by international laws or national laws. You're no longer seen as a human being. I don't want to go on any further. I'm prepared to answer your questions.
Thank you very much for your intervention. And now, as you said, I will give the floor to the judges.
Evet, sözü şimdi Hakim Bianco'ya veriyorum.
To this testimony, and I thank you very much for your testimony. The first, you said today that the fact that you're doing human rights projects and EU-related projects were used against you as evidence in the decision to even to arrest you. The second question is, when you mentioned this document, which was reproduced here in the screen, you said that this was the order of the High Council of Justice, but here the translation is the chief public prosecutor. So can you confirm this, which institution has issued this document, which is signed by Serdar Çoskun, Prosecutor General, is written here. And in addition, in paragraph 1 of this document is said that the list of judges and prosecutors who belong to Fethullahist terrorist organization in Turkey is enclosed here. My question is, was simply a list attached or individual orders of arrest for each of judges and prosecutors, and whether their individual facts related are included in these orders? So you are a lawyer, so you can make the distinction between these two elements. And my third question, if I may, Madam President, is you're referring to the fact that you don't have possibility of employment now in Turkey. Is there any act of Turkish government or any judicial authority in that regard, or is this simply administrative practice that you wouldn't be able to work? Thank you.
Evet, aslında şu
Yes, this document was signed by the prosecutor, by the public prosecutor, and the Ankara public prosecutor signed this, gave this order. But this decision cannot be given only by a public prosecutor, because for there to be a prosecution started against judges and prosecutors, then the High Council has to start the process itself. But on the 15th of July, there was the Ankara public prosecutor.
So a crisis table was created, which consisted of these people that I mentioned, so including members of the representatives or representatives of the Super Council of Judges and Prosecutors and members of the government and the Undersecretary of the Ministry. As you can see, it's a very hastily prepared decision. So even though you have the signature of the Public Prosecutor's Office, you have definitely a tacit agreement of the Ministry of Justice. Even though the Public Prosecutor's Office gave this decision for arrest, it was backed by previous agreements. So we talked about a list. So there are 245 colleagues on this list, including me. For such a list, you need at least 1 month. I also worked on such a council. You need to look at all the files. You need to look at all their professional practices in the past. You really need to check whether they perpetrated any crimes in the past, and then you need to select them out of 15,000 judges and prosecutors to draft such a list. But this was not done, because between 2014 and 2016, so 15th of July, in the whole judicial organization, we have Yargıda Birlik platform, which is a union in justice platform, and they are pro-government platform, and it also has been supported by opposition parties such as HDP, Vatan Party, and CHP. So they were defining themselves as patriots and nationalists, and they actually listed all the people that they considered as their opponents. So the Ministry of Justice and the presidency gathered a list, or they created a council which gathered this list. Therefore, when we came to the 15th of July, they already had a list, a pre-prepared list of all the judges and prosecutors that they considered dangerous. So there was a division, a polarization already in the judicial body, because the other judges and prosecutors, if they were to talk to me, if they were to engage with me, that would be a big risk for them. Therefore, psychologically speaking, all the judges and prosecutors who were members of this Yargıda Birlik Union and Judiciary Body platform were patriots, and all the others were traitors. That was already the psychological environment, the psychological climate, and 15th of July was used as an excuse. So all these lists were prepared in advance, and then they took action after 15th of July. The fact that I worked in the EU projects was used as evidence in my indictment, and they said that I used this to advance within the judicial bureaucracy, and they said that I was supported in my advance by a specific group, so they assisted me to advance in my career, and they presented this as evidence of me being a member of an organization. That was my struggle to gain my human rights, actually, but then it unfortunately turned into a crime. So actually my professional career, my educational background, and my social relations were put on trial. If you look at the evidence, you can see my Twitter posts, my Facebook chats, my friends, my social circle were reflected as evidence of crime. I would especially like to say the following. About these 5,000 judges and prosecutors, there were indictments prepared about them, but there is no evidence that they ever neglected their duty during the practice of their professions. So there is no evidence that they took opinions from outside or they were impartial. So in order to free me of my guarantees, you need to have an evidence which clearly shows that I neglected my duty and I committed crime. I'm not going to be humble. I think I've been a very successful public prosecutor. And I even didn't spend enough time with my family and children. I really dedicated myself to my profession. So I think this is a huge operation of silencing the opponents, the opposition. So that was the first step in order to silence all the opponents.
Pardon, I'm sorry. I will give the floor to you, Judge Pesce, to put your question to the witness.
Thank you very much, Madam President. You were sentenced to almost 8 years. So you must have been released, or you left detention before the expiry of your sentence, I guess. What are the circumstances under which your detention was ended? Then you also mentioned that you have established 2 organizations. Can I just ask you briefly what covers what these organizations deal with? And lastly, is all your work in Turkish and on the internet and so on? Thank you very much, Madam President.
Thank you.
So, yes, so there were 2 organizations that decided to purge me, Ministry of Justice and the Supreme Council of Judges and Prosecutors. The Undersecretary of the Ministry of Justice is a natural member of the Supreme Council of Judges and Prosecutors, and also the Ministry of Justice is also the head of this council. So, even though it is a council of 22 members, because of the psychological climate after the 15th of July, the Minister of Justice had full control, and the Undersecretary was used to shape the decisions of this council, rather than ensuring the impartiality and independence of the judiciary body. They threatened this, so this was the practice. They didn't allow any opposing voices, and they also wanted their colleagues, their friends, to take the decisions that they wanted, and otherwise they imposed sanctions on them. I was imprisoned for 30 months. So why did they release me afterwards? That's a very important question. So there were around 3,000 judges and prosecutors that were arrested. Their period of detention was more than 1 year because the Supreme Council of Judges and Prosecutors were going through a very important turning point. They delayed the preparation of our indictments for 2 years. So after I was arrested, they included some further data in my file after I was arrested, and that was dated December 2016. Therefore, when I was arrested from July until December 2016, there was no evidence against me, there was no data against me. So I had mentioned to you about this list that the Supreme Council of Judges and Prosecutors prepared. So they highlighted this list. So they created the categories of the enemies, so the most severe enemies, etc., or more moderate enemies. So the people who are in the red list are still in prison because I don't know why they really hate those judges and prosecutors, why they see them as enemies. Probably it's because of the investigations that they initiated against the party in power, and that's my guess. Probably I was less of enemy, so I was considered as a moderate enemy. So I believe that they gave the courts a right to have a discretionary judgment. So I also wrote petitions every day. Perhaps they couldn't resist anymore this illegality of their judgment, and they had to release me on the 18th of December in 2016. So there was no reason for my arrest. Also, in my release, I also didn't seek a judicial reason for my release because the whole process, the whole trial was not judicially sound at all. Yes, when it comes to the final, yeah, you asked me if my broadcast is in English or Turkish, so some of the articles I wrote are in English, but unfortunately, generally speaking, I broadcast in Turkish, in my channel.
Thank you very much. Now I'll give the floor to you, Judge van der Westhuizen.
Thank you, sir, very much for your testimony. It is indeed very disturbing to hear about the arrest and imprisonment of judges and prosecutors. We have heard sometimes very dramatic testimony on gruesome aspects such as torture and abduction. But speaking for myself, what I hear about the judicial system is to some extent, and perhaps on a different level, even more disturbing. This I say without having finally evaluated the evidence or without having come to a firm conclusion. My only question to you is, where do we go, where do you go from here? Do you think if what you say is correct, and if what the rapporteur said yesterday is correct, do you think there is a possibility that the integrity of the Turkish legal system, including all aspects, the professional freedom of practicing lawyers, the independence and integrity of judges, including all of that, is there a possibility that this could be restored? No judiciary and no legal system in the world is perfect, but there are some minimum standards for the public and the international community to have confidence in a legal system. We often talk about the legitimacy of a legal system. Do you think there is a possibility that the integrity and legitimacy of the Turkish legal system could be restored? And how do you think this could be done? And on a very modest level, what could this tribunal or any other tribunal or structure do to assist? Thank you.
Thank you very much.
So first of all, I would like to say that the fact that you are here is very pleasing for me and for other victims like me. I believe this is of great importance that you are all here. I said to you, I read the report of Mr. Luca Perilli. The fact that such a report has been prepared and that it's being shared by the global public is a very important step in order to reduce these illegal or unjust practices in Turkey. Of course, when it comes to any government institution and when it comes to their sound functioning, when it comes to their execution of their duties within the legality of the constitution and legal standards, this depends based on the request from the society. All the civil society, all the political parties in the society need to ask for an independent and impartial judicial system. But unfortunately, I can say it very clearly that I don't think this is a generally requested or demanded aim. So there were 5,000 judges and prosecutors like me who have been purged. We don't harbor any enmity. We don't harbor any hard feelings. We also try to find some reasons of our own in order to justify this victimization that we experienced. So we are expecting this as an opportunity, and we hope that there will be a time when we are restored to our duties again. Because this whole process has taught us something. I'm not only talking about these 5,000 judges and prosecutors, more than 200,000 public servants has been affected by this. The whole government has been polarized as the good ones and the bad ones. That's what I believe. And the good ones include people from all sectors of the society. So they were purged, they were dismissed based on the decrease in the force of law enacted by the government, and all of them know what the public duty is, what their fundamental rights and freedoms are, but they learned this the hard way by going in prison, by suffering all these insults and threats. Therefore, I believe that this freedom can be possible in a country where the people who have currently been purged are restored to their duties again when they are done justice again. And of course, this can only be done by conscious actions of the civil society. So the civil society needs to have this controlling role. So after the 15th of July, all my hopes were lost indeed, because when I started to work in Ankara, I had seen the bureaucratic functioning. And I also understood, unfortunately, it was I desperately saw the way in which the political parties and the civil society were working. Previously, I was dreaming of transforming things when I put on my judicial robe, but I unfortunately didn't see that was possible. I believe that the 15th of July gave us an opportunity, so the sectors that constitute society can come together around some common principles, some shared principles. And I believe this is the only way in which the Turkish state can guarantee freedoms and securities. So even though it was a very heartbreaking process, we have learned a lot from this process. I am dreaming about this, and when the opportunity is ripe, I would like to go back, and I also want to rely on my experience to work as a public prosecutor, but then I'm going to be, of course, more predictive and more aware. So I excitedly await this to happen one day.
Very much. Thank you. Thanks a lot. I don't think there is any other question. Now I would like to call 1 minute Judge Passé, because I think you have not a question for you, but he would ask you to do something. Could you have, Judge Passé, yes, could you ask the first witness, Mr. Faysal Sarıyıldız, about documentary and other evidence? So could you?
Yes, that's very
voilà.
kind of you,
Yeah.
Madam President. In the course of his testimony, Mr. Sarıyıldız referred to a video program, presumably, which apparently was made by or broadcast on Egyptian television, in which the circumstances he was describing were portrayed. It might be useful, if it is possible, for that program to be communicated to us, as well as any other documentation that may exist from those incidents that he was describing. I agree that his testimony did not really relate to the issues that were before the tribunal at this session, but I think that it doesn't hurt for us to have access to this information if it is easily accessible, please, if that's possible. Thank you very much indeed.
Kısaca bir şey söyleyebilir miyim?
Can I just say one thing? We have this document that you are mentioning. We also have many other documents. Perhaps I wasn't here in order to fully comply with the format of the session, but I felt it a bit strange because everything we have been talking about here for the last 3 or 4 days are very real and very important, but I'm talking about war crimes. I wish a couple of more minutes could have been allocated to discuss this. Now I understand the format, of course.
No.
Kayın problem ya.
No, thank you very much.
Madam President, this was not at all my intention. I just wanted.
I was willing to convey his question, and now, please, it's over. Okay?
Anladım, bitiriyorum. Yalnız bunu da
I would just like to wrap up. Please listen to me. I would just like you to know about how I think of this situation. Probably, maybe it was something to do with the organization. I wish you great success. Thank you.
I'm sorry, I will call the last witness, but it will be a digital testimony. Voilà, it's there, former judges. You have the floor.
Ben Süleyman Bozoğlu. Türkiye'de 15 yıl hakimlik yaptım. En son Yargıtay Ceza Genel Kurulu raportör hakimiydim. Türkiye'de hakim ve savcılar tarafından kurulan ilk meslek örgütü Yargıçlar ve Savcılar Derneği'nin kısa adıyla YARSAV'ın üyesiydim. 2012 ve 2014 yılları arasında YARSAV Yönetim Kurulu üyeliği yaptım. Benim 8 ve 15 yaşlarında 2 oğlum var. Her ikisi de otizmli ve %90 oranında engelli bireylerdir. Ben 15 Temmuz 2016 tarihinde meydana gelen askeri darbe teşebbüsünden 6 gün sonra, yani 22 Temmuz 2016 tarihinde tutuklandım. 16 ay 1 gün tutuklu yargılandıktan sonra 8 yıl 1 ay 15 gün hapis cezasına mahkum edildim ve aynı gün tahliye oldum. Öncelikle soruşturma aşamasında maruz kaldığım hukuk aykırılıklardan bahsetmek istiyorum. Aslında 15 Temmuz 2016 tarihinde ben fiilen görevde değildim. Çünkü 2015 yılının Eylül ayında çocuklarımın eğitim ve tedavileriyle ilgilenmek amacıyla 1 yıl ücretsiz izne ayrılmıştım. 15 Temmuz gecesi çocuklarım ve eşimle birlikte evimdeydim. Evim Ankara Emniyet Müdürlüğü'ne yaklaşık 900 metre mesafededir. Bu şu açıdan önemli. Ankara Emniyet Müdürlüğü o tarihte ciddi çatışmaların olduğu yerlerden birisiydim. O gece biz de çok korktuk. Çocuklarım sabaha kadar ağladı. Eşimle birlikte onları sakinleştirmek için uğraştık. Gecenin ilerleyen saatlerinde Ankara Başsavcı Vekilinin daha askeri kalkışmaya katılan askerler gözaltına alınmadan iki Anayasa Mahkemesi üyesi, onlarca Danıştay ve Yargıtay üyesi ve binlerce hakim savcı hakkında gözaltı kararı verildiğine ilişkin canlı yayındaki açıklaması üzerine bir gariplik olduğunu ben de hissettim. Fakat elimizden gelen bir şey de yoktu. 16 Temmuz günü HSYK'nın ve açığa aldığı ve hakkında gözaltı kararı verilenler arasında benim de ismimin olduğunu gördüm. Evde beklemeye başladım. 21 Temmuz günü evde usule aykırı şekilde benim olmadığım sırada bir arama işlemi gerçekleştirildi. Ben o sırada büyük oğlumun doktoruyla görüşmek için gitmiştim. Ardından arama tutanaklarından hakkımdaki gözaltı kararını Kırıkkale savcısının verdiğini anladım. Ve iki avukatımla birlikte Kırıkkale savcısının odasına 22 Temmuz günü gittik. Savcıya müracaat ettiğimizde savcı benim hakkımda anayasal düzeni değiştirmeye teşebbüs ve terör örgütü üyeliğinden Ankara Başsavcılığı'nın soruşturma başlattığını ve benim ifademi alması gerektiğini söyledi. O sırada hemen polislere haber verilmiş. 4-5 tane uzun namlulu silahla polisler savcının odasının kapısının önüne geldiler. İfade işlemi başladı. Savcıdan elindeki delillerin ne olduğunu sorduk. Sadece Ankara Başsavcılığı'nın üst yazısı ve ekinde bir hakim savcı listesi olduğunu ifade etti. Bu yazı ve listeyi de bize göstermedi. Anket tarzında sorular sordu. Ben bu sorulara cevapladım. Ve savcıya yaptığı soruşturmanın usule aykırı olduğunu, benim hakkımda soruşturma yapma yetkisi bulunmadığını, çünkü hakim savcılar hakkında soruşturma nasıl yapılacağını kanunda açık olduğunu ve bu şartların soruşturma dosyasında olmadığını, benim ortada bir suçüstü hali olmadığını açıkça söyledim. Buna rağmen savcı talimatın gereğini yapması gerektiğini ifade etti. İfademi alıp tutuklamaya sevk edeceğini ifade etti. Ben bu arada çocuklarımın durumuyla da ilgili, sağlık durumuyla da ilgili bilgiler verdim. Kendisine sağlık kurulu raporlarını verdim çocuklarımın. Ama buna rağmen tutuklamaya sevk etti beni. Ardından suç ceza hakiminin önüne gittik. Sorgu sırasında aynı diyaloglar yaşandı. Hakim herhangi bir delilin olmadığını, Ankara Başsavcılığı'nın yazısı ve liste dışında dosyada herhangi bir belgenin olmadığını ifade etti. Hakimden ısrarla şunu talep ettim. Çocuklarımın sağlık durumlarını ifade ederek özellikle büyük oğlumun bana çok bağımlı olduğunu, o yaşa kadar bütün eğitim ve tedavileriyle benim ilgilendiğimi, tutuklanmam durumunda çok ağır sonuçların olacağını açıkça söyledim. Sağlık kurulu raporlarını verdim. Çocuğun gelişim raporlarını hakime verdim. Avukatlarım da ısrarla benim adli kontrolle bırakılmamı istediler. Fakat hakim beni anayasal düzeni yıkmaya teşebbüs ve terör örgütü üyeliği artı anayasal düzeni yıkmaya teşebbüs sırasında başka suç işlemek gibi garip bir suçlamayla tutuklanmama karar verdi. Tutuklandıktan sonra yaşadıklarımı ifade etmek istiyorum. Cezaevinde en büyük sorun avukat görüşüydü. Ben tutuklandıktan hemen sonra avukat görüşmeleri sınırlandırıldı. Bu yarım saat olarak belirlendi. Yarım saatlik süre tabii ki çok sınırlı. Bu süre sınırının dışında en önemlisi görüntülü ve sesli kayıt alınma uygulaması getirildi. Yaklaşık 5 ayda memur, ayrıca bir memur sizin yanınızda bekliyordu. Avukatla görüşüyorsunuz, o sizin görüşmelerinizi dinliyor, not alıyor. Böyle bir ortamda görüşmeler yapıldı. Yaklaşık 11 ay sonra hakkımda iddianame düzenlendi. İddianame düzenleninceye kadar tutukluluk devam kararları dosya üzerinden verildi. Hakim karşısına çıkarılmadım. Tutuklama incelemeleri dosya üzerinden yapıldığı için ben herhangi bir hakim görmedim. Tutukluluk devam kararları süresinde bana tebliğ edilmedi. Devam kararı 4 ay sonra, 5 ay sonra, 3 ay sonra tarafıma tebliğ edildi. Bu anlamda itiraz hakkımı da kullanamadım. Öte yandan tutukluluk devam kararlarında bizim kanunumuzda zorunlu olan 30 günlük azami ve emredici süreye de uyulmadı. Bu ne demek? Hakim 30 gün içerisinde tutukluluk devam kararıyla ilgili bir inceleme yapması ve bunu devam ya da tahliye olarak değerlendirilmesi gerekir. Bunlar 35 günde, 36 günde, 40 günde yapıldı. Bu da bizim kanunumuza açıkça aykırıdır. Kişiyi bu durumda kesin olarak tahliye etmek gerekir. Ancak bu uygulama yapılmadı. Tutukluluk devam kararlarıyla ilgili olarak söyleyeceklerim bundan ibaret. Yargılama aşamasında avukat görüşlerindeki sınırlamalar devam etti. Yarım saat ve görüntülü ve sesli kayıt alınmak suretiyle avukat görüşleri yapılıyordu. Bu ortamda sağlıklı hukuki yardım almak mümkün olmadı. Avukatlarıma yazmış olduğum mektuplar idare tarafından okunuyor ve üzerlerine görüldü mührü vuruluyordu. Bu da etkin savunma hazırlığı yapmamıza engel oldu. İddianame mahkeme tarafından bana tebliğ edildikten sonra ben mahkemeden dosyadaki tüm delillerin, dijital ve kağıt delillerin tarafıma gönderilmesini istedim. Fakat mahkeme bu talebimi karşılamadı. Özellikle dijital delillere hiçbir aşamada ulaşamadık. Avukatlarım dahi ulaşamadılar. Çünkü dijital deliller dosyada CD olarak değil, mahkemenin kasasında saklanıyormuş. Bu verilere, bu delillere hiçbir zaman ulaşamadık. Mahkemeden özellikle iddianamede bahsedilen 2 tane tutanak var. Onların Ankara Başsavcılığından istenerek tarafıma gönderilmesini talep ettim. Mahkeme bu talebi de karşılamadı. Bu tutanaklar hakim savcılar hakkında yapılan soruşturmanın usulsüzlüğünü ortaya koyan tutanaklardı esasında. Çünkü iddianamenin giriş kısmında soruşturmanın 15 Temmuz gecesi başladığı yazılmış. Fakat bir sonraki paragrafta 18 Temmuz tarihinde tutulan 2 tane tutanak sonrasında soruşturmanın başladığı ve genişletildiği yazmakta. Bu usulsüzlüğü ortaya çıkarabilmem için bu tutanaklara ulaşmam gerekiyordu. Fakat mahkeme bunları istemedi Ankara Başsavcılığından ve bize ulaştırmadı. Bu tutanaklara hiç kimse ulaşamadı. Bu tutanaklar şu anda Ankara Başsavcılığı'nın kasasında hala saklanıyor. Tanık beyanlarıyla ilgili anlatmak istediklerim şunlar. Mahkeme benim hakkımda 2 tanık dinledi. Bu tanıkların ortak özelliği geçmişte hakim olan, benimle aynı soruşturma kapsamında şüpheli sıfatıyla soruşturma geçiren ve sonrasında etkin pişmanlık hükümlerinden yararlanan kişilerdi. Bu tanıkların birisi açık tanıktı. Tanık Kazım Uslu. Ve diğeri gizli tanık, tanık Sinop adıyla kayıtlarda geçiyor. Daha sonra kimliği deşifre oldu. O da Süleyman Savut. Ben bu tanıkların anlatımlarını çürütmek açısından bazı taleplerde bulundum. Mahkeme bu talepleri kabul etmedi ve tanıkların anlatımlarını çürütme imkanım elinden alındı. Mahkemenin tarafsızlığı ve bağımsızlığı ile ilgili başından geçen 2 olayı da aktarmak istiyorum. İlk olay 1. duruşmada meydana geldi. 1. duruşmanın sonunda henüz duruşma bitmeden mahkeme başkanı ara kararları yazdırdığı sırada mahkemenin üyesi askerlere hitaben duruşma bitti, sanığı kelepçeleyin ve duruşma salonundan çıkarın dedi. Bunun üzerine askerler telaşlandılar ve beni başkan daha ara kararları yazdırır iken mahkemenin huzurunda eşimin, arkadaşlarımın ve avukatlarımın bulunduğu ortamda orada kelepçelediler. Ve hızlıca beni duruşma salonundan çıkardılar. Bu bizim yasal mevzuatımıza göre yasak bir uygulamadır. Çünkü tutuklu sanık mahkeme huzurundayken, yani duruşma devam ederken asla kelepçelenmez. Yasal olarak yasaktır bu uygulama. Fakat bunu neden yaptılar? Şundan yapıyorlar bunu. Beni arkadaşlarımın, avukatlarımın, eşimin önünde onurumu kırmak için, rencide etmek için, küçük düşürtmek için bunu yaptılar. Bunu ifade etmek istedim. İkinci olay da ikinci duruşmada meydana geldi. İkinci duruşmada savcı esas hakkındaki mütalasını açıkladı. Ben ve avukatlarım esas hakkındaki mütalaya karşı savunma yapmak üzere süre istedik. Aynı zamanda çocuklarımın sağlık durumlarını da dile getirmek suretiyle tahliye talebinde bulunduk. Bu tahliye talebi üzerine mahkeme başkanı bana sizin tahliyenizi hükümle birlikte değerlendireceğiz. Eğer süre istemezseniz tahliyenizle ilgili bir karar vereceğiz dedi. Ben şunu anladım, beni tahliye etmek istiyor ancak benim de süre almamı istemiyor, süre talep etmemi istemiyor. Fakat ben savcının suçlamaları çok ağır olduğu için ben sürede ısrar ettim ve tahliye olmak konusunda da ısrarcı oldum. Fakat mahkeme bunu uygun görmedi, tutukluluğumun devamına karar verdi ve bana yaklaşık 1 aylık bir süre verdi. Duruşma salonundan bu kez kelepçelemediler. Dışarıya çıkardılar beni duruşma salonundan. Duruşma salonundan dışarıya çıktıktan sonra bekleme alanı var. Tutukluların duruşmadan önce bekledikleri bir alan var. Orada askerler, ben bir de benden sonra duruşmaya girecek olan başka bir tutuklu hakim oradayken mahkemenin savcısı başkana hitaben bizim de duyacağımız şekilde çok net bir ifade kullandı. Başkanım, Süleyman Bozoğlu'na 7 yıl 6 ay az olur dedi. Bunu ben duydum. Başkan bu ifadeye karşı bir şeyler söyledi fakat onu ben duyamadım. Askerler de bunu duydular ve telaşlandılar bu durum karşısında. Beni apar topar alt kattaki başka bir yere götürdüler. Bir sonraki celse ben duruşmaya geldim. Esas hakkındaki savunmamı yaptım. Mahkeme bu kez bana 8 yıl 1 ay 15 gün hüküm vermek suretiyle beni tahliye etti. Ben bunu takdirini sizlere bırakıyorum. Tabii ki benim de bununla ilgili bir yorumum var. Fakat anlatacaklarım bu kadar. Teşekkür ediyorum.
The testimony is over now. Thank you very much for it, and I will give the floor to the judges who are willing to put some questions. I will start with Judge Bianco and then Judge Malinverni. Judge Bianco, you have the floor.
Thank you, Madam President, and thank you for your testimony. I have one clarification on what you said and one question which is more general, and probably the rapporteur, Mr. Perilli, as well can help us on that. You're saying that you're sentenced with 8 years, 1 month, and 5 days, if I'm not mistaken. How come that you were released then earlier than this period expired? I mean, what are the circumstances of your release? Why? How did the court justify sentencing you and then releasing you without being in prison for the entire sentencing period? And then the general question is, both the testimonies we heard, the second witness and the third witness we heard today, were referring to the list prepared by the High Council of Justice and then the prosecutor. So my question is in general, do you know whether all judges and prosecutors included in this list were dismissed, arrested systematically, and then released in different periods of time? Or there was any specific or few cases in which these judges and prosecutors belonging to this list were not arrested? So this is my question.
Thank you very much. I will give the floor immediately to Judge Malinverni because this question is related to yours.
Yes, thank you, Madam President. I would like to ask maybe to the previous speaker, but also to you and to Mr. Petrilli. the list of these suspicious judges has been prepared already before the court. My question is, upon which criteria this list was prepared? And who prepared the list, you said already, Mr. Bianco. But since I have the floor, I would like to ask my second question already, or later.
No, I do
as you-
prefer that we are going
Okay,
back
okay,
in that,
okay.
and then you will have the floor again.
Yeah.
Okay.
Yes, President and members, first of all, I would like to extend you my respect. The first question. So the court, yes, at the last session, they convicted me to 8 years and 1 month, 5 days. And the explanation for this, there was no concrete explanation for this, justification for this. But when it came to my release, I have 2 autistic children. I have 2 children who have autism, and of course I have to take care of them. Their education is problematic, and so they released me for the sake of my 2 children with autism. On the night of the 15th of July, right after the coup, the Office of the Chief Public Prosecutor of Ankara started an investigation. But there is no real judicial reason for this. It was more of an excuse. And that night, they say it happened on the 16th of July, but it was just a few hours after the 15th of July, not within 24 hours of the 15th of July. Because what happened on the 15th of July started at around 9 o'clock, 9 p.m. And so the Office of the Chief Public Prosecutor of Ankara made his announcement on the night of 15th of July at around 1:30 a.m. And so they said that they were going to start an investigation on 2,745 judges and prosecutors. And this investigation started at around 2 a.m. of the night tying 15th to 16th of July. And so all of the 2,745 judges and prosecutors were taken under custody. But of course, there is a huge number here, and some of them were taken under custody only a few days later. And so they came to my house to take me under custody on the 21st of July. And on the other days, on the following days, every single of these 2,745 judges and prosecutors were taken under custody. 2,000 of them were arrested. And of course, there were some who were not arrested. But there's no judicial reason, there's no legal reason for which they were not arrested. And anyways, we weren't arrested for any real reason either. As I said, there's this document shown by Hasan Bey, and then there's the list in annex. But there's nothing about each person. There's only their name and their last name. There are no other details on this list. And so the prosecution was started, and those who were not arrested, some of them were said to have health problems, and so they weren't arrested. But the majority of those who weren't arrested were women judges. And so they had children of small age. And sometimes it was a wife and husband who were a judge and prosecutor, and they were going to be arrested together. But then it was the male who was arrested, and the female was left alone, was not arrested. That's how they preferred to proceed. And so of the 2,745 judges and prosecutors, some were taken under custody and arrested, and some, of course, were not. Oh, no. And some, of course, were not arrested, but those are only around 150 people.
Peki bu liste
The interpreter apologizes. It's not 2,000, it's only 245. And so this was based on the elections of the Council of the Council of Prosecutors and Judges done in 2014. And those who had prepared the list of candidates and
Tüm adliyelerde bir takım
and those who prepared those lists were preparing this in a very organized way.
toplantılar yaptılar. O toplantılarda edindik.
So this platform, Yargıda Birlik, which is the union and judicial body that we mentioned before, came together in meetings, and they were actually preparing a list of the judges and prosecutors. So they were profiling the judges and prosecutors that would be purged after the 15th of July. That's how this list was drafted. Thank you.
Thank you very much. Would you like to add something on that, or? Yes.
listelerin nasıl oluşturulduğunu
So as it comes to how the lists were drafted, I can make an addition. Of course, in order to understand this, you need to know what this Yargıda Birlik platform, this platform, pro-government platform of union and judiciary body means. So after the graft operations of the 17 to 25 December operations, AK Party, the party in government, wanted to control the judiciary body. They had secret gatherings with the other opposition parties, CHP, HDP, and Vatan Party. So these are opposing parties. As a person who worked for 14 years in the judiciary body, I saw that each and every judge and prosecutor comes from a specific sector of society, and they are ideologically linked. So they have certain ideological opinions, and that's how human beings are anyway. So the people who constructed this platform are leftists, political Islamists, conservative, nationalists, and pro-nation or patriots. So these groups represented these different sectors of the society. They gathered a list of the judges and prosecutors who they knew had their allegiance to them. They said, these are under our control, these are judges and prosecutors that would never ever harm the party in power. So they had such a list. And then they looked at the judges and prosecutors who they couldn't really identify. They didn't know what their ideological allegiances were. So they had the following criteria. As I mentioned before, if a judge and prosecutor throughout their professional career since the beginning had been working to improve themselves, including foreign language education, graduate education, PhD education, or other personal development efforts were at stake, or if this person had very good relations with other human beings, if they were really polite and they had a good ethics standards, or if they didn't experience any specific investigations during their career, according to the people who were in this Yargıda Birlik platform, these judges and prosecutors could be so good only if they had other motivations. So they had these estimates because they were saying that these judges and prosecutors would otherwise have only been ordinary judges and prosecutors like us. So these were the criteria.
Now I'll give the floor again to you, Judge Madine Verny.
Thank you. Just a second question. I can imagine that some of the prosecutors and of the judges who examined your cases knew you because they were your former colleagues. So my question is, what was their attitude judging former colleagues? Did they refuse to sit in the court or prosecute because you were a former colleague?
So, yes, our former colleagues, when it comes to the denial of their requests or when it comes to the way in which other people saw them as enemies, their motivations were actually self-protection. They just had this instinct to protect themselves because, as Süleyman Bey mentioned, the party in power had been using all of the possibilities of the state. They wanted to punish everybody who was not on their side but who was against them. And they made written statements. They also went through all the bodies of the government or in all the offices of the government. They explained this. And they also said that they would punish all the judges and prosecutors that didn't show their allegiance to them. They had their lists, but because they didn't have the legislation available to them, they couldn't yet act swiftly. And they were saying, we wished we had better legislation to take swifter actions, because it's not possible to purge 5,000 judges and prosecutors via disciplinary action, but their efforts were underway. So there was an environment of fear in the judiciary body. It's really difficult to stand against this on your own. You can only act with other colleagues who you thought shared the same opinions with you. Actually, these 5,000 judges and prosecutors gathered together around their principles, and the other ones gathered on the common platform of fear. So as a result of these unjust decisions, they have been awarded. They have become member of the Council of State or Court of Cassation. And some of them actually had very important disciplinary investigations that had been initiated against them. They had those closed or put under the carpet. Unfortunately, I see that they also had some financial benefits via state tenders, or their relatives benefited from state favors. So this was the polarization that I'm talking about in the judiciary body. Of course, ideologically speaking, there were people who didn't appreciate my political opinion and my life standards. So there was also a significant group of judges and prosecutors who took it as a duty, ideologically speaking, to act against me.
Thank you very much. Judge
Sayın Başkanım, ben eğer
Distinguished President, I would also like to say a few words about this, if you allow me. Distinguished President, so in Ankara, 5th Peace Court of Criminal Jurisdiction has a ruling about more than 1,000 judges and prosecutors. I would like to show you their ruling about the continuation of the arrest of the judges and prosecutors. Of course, this ruling was signed by a judge. There are certain figures on it. There are certain names. And all of them are judges and prosecutors who were arrested in prison at that period of time. But there is no rationale, or there is no reason of this ruling. The reason part is but a small paragraph, and the reason is not legal. So for more than 1,000 people, you give a ruling to continue their arrest, and you don't specify any individual criteria about these people, and there is no proportionality anyway. So our former colleagues justify themselves as follows. They say, we know there is no evidence in the file, but on the other hand, they also know that we cannot be associated with such crimes that were ascribed to us, but in art they refer to this catalog crime of Article 100/3 of the Turkish Penal Code. Mr. Luca Perillo also mentioned this yesterday in his presentation. This anti-terrorism law is being abused very clearly in this ruling. So our former colleagues know us. Of course, most of them know us from the corridors of the judicial departments. We worked in the same buildings. We lived in the same apartment complexes. Our children were friends, and sometimes we also gathered socially. But because of this climate of fear, they signed such rulings, and also because they were politically member of a certain sector, they use this catalog crime, which is defined in the Article 100/3 of the Turkish Criminal Code. They relied on this ruling. So Article 314/2 of the Turkish Criminal Code was used. So even though you don't have any direct association with this organization, they abused this article of the anti-terrorism law, and they decided to have this ruling to continue the arrest of all these judges and prosecutors, and they didn't even feel the need to specify clearly the reason for their ruling. And I think this is important to show that our former colleagues have a motivation. They are not legally motivated or judicially motivated. They don't care about substantial facts. They just want to incriminate people, to draft a list. And they are basing themselves on their previously held judgments. So these trials didn't seek to find the truth. You can say whatever you want. You can say we want the evidence to be collected or we want the evidence to be assessed in order to show that some of the testimonies are false. We would like to show some evidence. So we were saying all this. Mr. Luca Perilla also mentioned this very clearly in his presentation. Yarsa chairman, Mr. Murat Arslan, wanted to be... I wanted him to be heard as a witness in my trial because one of the accusations against me was that I was a member of Yarsa judiciary board. So the court didn't accept this. That's all I would like to say.
May I ask you to provide the tribunal with the list?
If you can, please, with this decision on prolonging the detention period that you mentioned, with 1,000 names attached to it. If you can deliver us or send, okay, it's perfect.
No, thank you, Madam President. I have two questions, and I think you've partially answered one. But Mr. Bozoğlu, I would like to ask you, why do you believe you were targeted and included in that list? That's my first question, and then I'll ask you another very short one.
Why was I targeted? First and foremost, because I'd like to give you some information about Yarsav, this organization of Association of Judges and Prosecutors. This was a professional organization. It's a member of Medan and IAJ, so it's an internationally recognized association. I was a member of Yarsav. And also, between 2012 and 2014, I worked in the board, so in the executive board of this association. So specifically for me, we weren't targeted on the 15th of July. We were targeted before that. So I learned about this coincidentally in a decision for lack of grounds for legal action. I learned about this. So before the Supreme Council of Judges and Prosecutors election in October in 2014, for 3 months, my phone was tapped for intelligence purposes. Why were they doing this? They wanted to learn the kinds of actions that Yarsa was taking before the elections for the board of the association. That was the main reason, because I was a member of Yarsa, I was an active member, so that was the first reason. And the other thing is that I worked in the General Assembly of the Court of Cassation. So this is the highest level board of case law when it comes to criminal law within the Court of Cassation. And it investigates the doctrine of some decisions. So there, I know that the political party had a critical role in a few cases that I reported on. So I was a rapporteur on a few cases where the government was also affected. I think these were the reasons. I don't think any other reasons were there.
Thank you. And the other question is whether the lawyers that represented you had faced any consequence, any retaliation for the role in your criminal defense.
Yes, I had 2 lawyers during the criminal case trial, during the criminal defense, and in the aftermath. They didn't see any retaliations, but they were very cautious during the whole process. They would come to meet me in prison. They would almost never talk about legal subjects with me. They also weren't able to give any information outside because there was a decision for secrecy about the file, so they also couldn't access my file, my case file. They were just visiting me in prison. They were telling me, be careful for your health, your children are okay, your wife is doing well, please keep your morals high. That's just what they were telling me, and I also never received sound legal assistance from them in this period. I cannot say that. But then they were anxious that the phones were being tapped, so our interviews were being tapped. They were mentioning that too.
Judge Bozoğlu, I hope I'm not pronouncing your name too incorrectly. As I asked the previous witness, assuming that what you told us is true and correct, what is the way forward? Can the legal system of Turkey be rescued? By whom and how? And what role do you think can this tribunal play, if any? That's my first question. I have another very short one.
Distinguished judge, it's a wonderful question. Thank you. I have been thinking about this question for a long time. Also, when I was in prison, I thought long and hard about this question. Yes, I'm really not hopeful. I don't see a positive trend. I really don't have any hopes that we are going to obtain a positive result as a result of all of these. But what can we do? Of course, it's not always about law, or it's not always the legal platform, but we also express our experience on the international platforms, in the international arena. We can operate some other procedures or processes. We actually have no other way than explaining what law and what justice are. So the Justice Academy used to be an independent educational body. Back then, I used to teach about criminal procedural law. So I was teaching about criminal code and the trials associated with this in the Judicial Academy when it was an independent organization. So in the presentations, there were also some expressions related to the potential future situations. I partially agree with them, and I see that we don't have any other remedies than just working and explaining what justice and what law are.
Yes. Thank you. As you say, it's not only about law. Very last question. We are not only dealing here with abstract concepts, but with people. So very last questions. How are your autistic sons doing now?
Distinguished judge, yes, from my perspective, this is an emotionally charged matter. It's a very personal, private matter. I hope I will be able to say something objective. So my older son, who is currently 15 years of age, when I was arrested, he was 9 years old. He was 9 years old. And he had received some special education. We also supported him. We really exerted great efforts. My wife, including my parents, the whole family, exerted their efforts, and he had made great progress. He had started a primary school as a student who was part of this integration program. He learned how to read and write, but then all these unfortunate circumstances happened to us, and his education was interrupted. He went through significant trauma. This is in the report, so I don't see a reason why I shouldn't say this openly. His speech deteriorated. His speaking skills deteriorated almost every day. He was waiting for me to come home. He kept talking about this, about me coming home every day. When I was arrested, his level of disability was around 70%. This is something that's in the report. But about 2 months after my arrest, once again, his developmental progress was evaluated, and his disability rate had increased to 90%. Because he had lost some of his speech skills, and he was suffering from difficulties in his social relationships, and he often had episodes of anger. He even sometimes harmed himself or his mother. And right now, after I was released from prison, of course, there have been some improvements, but certain things are irreversible, unfortunately. Some damage is irreversible.
For this very courageous testimony. Now we will adjourn the session and we will meet back here in 15 minutes. It means at noon to listen to. No, we will have a comfort break now. Voilà, a comfort break if you don't mind. That's Voilà, technical one. Thank you very much. Thank you, all of you. Thank you very much for what you have done. Et see you in 15 minutes.
All rise.
Oh, no.
Good morning again, or good afternoon, we are just in between. Thank you very much for being there, so numerous today. Now we will have the last intervention of this session, and it will be by Professor Dr. Johan Vande Lanotte on crime against humanity. So we'll listen to your report, and thank you very much in advance.
Thank you very much, Madam President, dear members of the Tribunal, registers, Marielle, dear ladies and gentlemen. This presentation about crimes against humanity originally was not foreseen. We only started it after 1 year of work. And that gives a good impression about the importance of this topic that we did not take lightly in consideration. What we will try to do today is examine if the facts of torture and enforced disappearance do meet the legal requirements needed, the contextual elements, as they say, needed to be considered as crimes against humanity. Crimes against humanity, perhaps a short introduction, also for the audience. We have violations of human rights, but that's not the same. Crimes against humanity go further. It is only the gross violation of human rights that can be considered as crimes against humanity. In our case, torture, enforced disappearance, also the arbitrary detentions. However, we had not made a specific report on that, so I will not take that in account in our conclusions today. Perhaps we will do that later. In a specific context, and this specific context makes, that's the reason why you have this figure, makes it necessary that the international community acts against these violations. The origin is after the Second World War. We had the figure of war crimes before, and after the Second World War, the international community found out that we should go further with acts against crimes against humanity, which is not linked to warfare, and which is much more towards the civilian population. And that ended with the Rome Statute, with a codification, bringing some innovation, some limitations, and the creation of the International Criminal Court. However, in the rules of procedure of our own tribunal, the jurisdiction of the Turkey Tribunal covers human rights conventions ratified by the Republic of Turkey and the respect of the general principles of international law. Turkey did not ratify the Rome Statute, but crimes against humanity are part of customary international law and therefore also under the jurisdiction of the tribunal. However, in the methodology we have taken the most severe criteria all the time. This means when customary international law is more strict, like for instance in the case of torture, we use the definition in the report of torture that is under the customary international law, which means the intention to get confessions and so on, which is not needed in the Rome Statute. And where the Rome Statute is more strict, that is the needed to a policy, we applied the criteria of the Rome Statute. So we wanted, as you could say, we're a bit more stricter than customary international law. What we will say is not about individual responsibility. It's not about that. The fact who is responsible, for what are they responsible, and not about the jurisdiction, the competence of the national courts or the ICC. That are topics certainly interesting and not easy to answer, but not in our report. I will not take too much time on the facts of tortures and forced disappearance, because we had these reports. We had the estimation of the 3,000 allegations, complaints about torture yearly. We have the 95 well-documented abductions. I will not come back on that. We have the reports on that, would be a waste of time. And I will not take into account the arbitrary detentions and the conditions, which is also under Rome Statute one of the elements of crimes against humanity. The presentation, well, the facts, gross human rights violations as torture and enforced disappearance, do they meet the legal requirement, what usually is called contextual elements, to be considered as crimes against humanity? And we have two steps, two stages in that. The first step is, do we have an attack? That's how it is called. And the existence of an attack has three elements that are crucial. First, it must be a course of conduct involving the multiple commission of acts, here acts, torture, and forced disappearance, first. Secondly, the operation, the act must be directed against the civilian population. And thirdly, and that's for the Rome Statute, not for customary law, that operation must be conducted pursuant or in furtherance of a state or organizational policy. I must say that we will see when we have it about course of conduct policy and later on about systematic. These terms are very much linked to each other. It's not always easy to make the clear difference between each element of it. And it is more the global appreciation, I think, that will be determining our efforts. So, course of conduct. I have taken some elements from the jurisprudence of the ICC, and I think I gave to the register an overview of the jurisprudence. So you will allow that I will not go too much in detail in that. I'm not saying each time this is from this judgment, this judgment. You find it in the document that I delivered to the tribunal. What we see in this jurisprudence, I will take the third bullet as the one who is most clear on that. So a course of conduct is not designed to capture single isolated acts, but describes a series or overall flow of events as opposed to a mere aggregate of random acts. So if you have an act of torture today and without any link, 2 months later you have it again, and it happens 1 month later in another place without a link, how cruel, how important this torture could be, it cannot be described as a crime against humanity, because we lack this link between them. It is a random act, it is isolated as, and that cannot be taken in account. It's very important, that element, the course of conduct, and we see the words collectively in the second bullet. We see the commonality. There has to be a group of acts. It's very important, and that makes the difference with isolated acts. And secondly, the course of conduct involve multiple commission of acts, which means a few, several, many, that's what we find. But to say there is an attack, this quantitative demand is not very specific. We will find it back in the widespread requirement. It must be multiple, more than a few. Now, let's apply these elements to torture and then to abduction, with perhaps, and I make this exception, the short period after the coup, the attempt of coup, where it is possible that people were mad, were angry, that we have a spontaneous reaction of police officers, security officers. That's possible, it happened. That doesn't want to say that it's acceptable, but it means that the conditions to consider that part as crimes against humanity is doubtful, because there was probably some impulsive reaction to react on what happened. But making exception for that period, we cannot not ignore that acts of torture, as it has been described in the reports, as it has been testified by witnesses here, we cannot see them as a spontaneous act of individual security officers or simply as a mere aggregate of random act. There is a course of contact. We see the torture to obtain confessions from the terrorists, We see to get new so-called terrorist names. We see a system in how it works. And we also see that the systematically, and I already used that word, is very clear in who they target, the specific group targeted groups of people belonging to the Gulen movement, people belonging to the Kurdish movement, people opposing. There is something, you cannot say it's hazardous, you cannot say it is random. There is a pattern in it. And of course, the acts of torture fulfill the needed quantitative threshold. There are more than a few. It is a bit cynical to say that today it's more than a few if we have 3,000 allegations and perhaps more in a year. It's a bit hard to say that it's more than a few. So I think this torture system, what we see that happened, it's not hazardous. There is a system in it. There is a pattern in it, and it's directed to targeted groups. For enforced disappearance, it's even more, it's easier because, the nature of an abduction itself is not something that is hazardous. It's not something that suddenly happens. It's not so that suddenly a policeman says, okay, we will capture today someone. That doesn't go like that. We saw that the actions were with many of them, were organized. You need to have a place where you put the person in a specific place, specific infrastructure. And we saw afterwards that they were delivered, between brackets, to the police, and nearly always the same, discovered as such, whatever spontaneous coming to the police. You cannot have abductions in 95 cases without being prepared, and even one case of abduction nearly is impossible. So I think the intense preparation, the secret detention facilities, the acts of abduction himself cannot be seen as spontaneous acts of individual security officers. And the specific group, which certainly for the last periods nearly completely, or not completely, but nearly completely, people belonging to the Gulen movement, makes us to conclude that indeed this is a conduct, that is something that is a pattern that we can discover. The acts must be directed against a civilian population. Of course, I already told, we coming from a system of war crimes to crimes against humanity, and in addition to the international criminal law, if I can say. And so it is not longer an act against the military or from militaries. It is the civil population who is involved, and that we see the civil population comprises all persons who are civilians as opposed to members of armed forces and other legitimate combatants. But that's not enough, because we see that the qualifier, any civil population, means groups distinguishable by nationality, ethnicity, or other distinguishing features. The civilian population targeted can include a group defined by its perceived political affiliation. So it is a group that has to be identifiable. The term civilian population, we see, that's the last bullet, denotes a collective as opposed to individual civilians. So it is not said it is directed against a civil person. It is said it is directed against a civil population. The term population means that it is about a group. It's not about an individual. That's an important nuance we have to make. As far as the Turkish situation is, there's no against military, there is no military involved, so it is civilians. The question, is it a population? I think indeed it's clear that even more for the abductions than for the torture. We have also seen that torturing is also directed to some, let's say, common criminal situations, to other situations, but those who were reported in our reports are directed, again, the same groups, the groups of the Gulen movement, the Turkish movement, and political opponents. Political opponents, a bit less, there or less, it's most of all the Gulen movement and the Kurdish movement, and for the abductions, nearly exclusively the situation. Though civilian and population, I think that is, let's say, clear. However, the most important element, I think, is together with the last ones that we will look at. Sorry, yeah, is the third one, pursuant or in furtherance of a state or organizational policy. Forget about the organizational policy. That is in cases where the state is not longer functioning and that we have paramilitary situations. That's not our case. Our case is about state responsibility, state possibility, policy, excuse me. This requirement is not present as such in customary international law. However, the systematic requirement in the customary international law is nearly the same as the policy. It's not a big difference, actually. It's very close to each other. What are the elements that we see in the jurisprudence? We see thoroughly organized as an element, a regular pattern, involving public resources, private resources, and also in the jurisprudence, it need not to be explicitly formulated or defined. We can deduct it from acts. We also see promoted or encouraged by the state. We also see repeated action according to a same sequence, preparations, collective mobilization, and an attack which is planned, directed, or organized, as opposed to spontaneous or isolated acts, will satisfy the policy criteria. Again, this conduct, course of conduct is very close to that. That's what we find in the jurisdiction until now. How can we apply that in the Turkish situation? And I find personally this is where the other one, the course of conduct and against the civilian population, let's say this is not something you have to break your head on. This one saying, is there a policy? It is indeed our view that the state at different levels of power, and I emphasize this, it's not needed. We do not need to have all the different levels, but I emphasize it, has actively promoted and encouraged a policy of torture and abductions, organized it, and used all the necessary resources to achieve certain objectives. Although it's not a requirement, some parts of the policy were also explicitly put forward. I know that this is a heavy statement. It's a sharp statement, but I will try to explain why I came to that conclusion. The different levels first, what I have called here the non-ignorant legislator. There were clear warnings from international institutions that the law, which defines terrorism as broadly as possible and is abused, as has been explained by Judge Perilli, by the justice, to put everything that's possible under terrorism as Amnesty International. At the end, everyone who opposes the government can be considered as a terrorist. The legislation concerning prior authorization of prosecution of heavy, strong violations, which mean that although in the law, torture and enforced disappearance for sure are sanctioned by heavy penalties, but laws who make it depending on authorizations make that this law is nearly inoperative, as we saw from the figures. And also immunity legislations that has been put forward not only after the coup, where has been said everyone after the coup who did something wrong, we forgive you, but also the MIT, the Secret Service, who clearly got an immunity status for what they were doing. The first witness this morning also gave this letter for before they started to say, you will be cleared, you will have no problem. This legislation, knowing the consequences, they were informed of the consequences by international institutions and by the European Court of Human Rights, who said, this is too broad, you cannot apply, it's against the principles. Still they maintained it. That's why I'm saying it is not non-ignorant. They did not do it because they didn't think about it, this legislation is not only a condition to continue with torture and with enforced disappearance, but it is an encouragement to do it. I cannot evaluate it differently. Secondly, the executive branch. We have an official zero tolerance. We have the statements in the report on torture that make me give an interpretation. It's an interpretation, I admit, where it said we have an official zero policy on torture, so torture cannot happen. So it should not be prosecuted. And the zero tolerance policy leads to a zero prosecution policy. It's clearly stated. The minister said we do not need to, it cannot happen. And so this policy of zero torture is a bit easy as an excuse. Anyhow, we see there are allegations and there are very few convictions. But perhaps most, and that is not an interpretation, that's a fact, different reports, and also the, I must say, very credible and strong testimony of Mustafa Özben, who described this secret facility where people are tortured and interrogated in specific ways, and also reports and visits that has been made at a certain moment have declared that there were specific infrastructures. If you have specific structures for torturing, that means you have a policy to organize to do it, otherwise you will not have an infrastructure. And I refer also to the CPT reports of the visits of 2017 and 19, so again, 3 years after the attempt of coup d'etat, where the CPT say there are specialized units, mobile units, the Yunus brigades, who are specialized in torture, and they intervene when it is needed to help and to make the torturing effective. If you have infrastructure and you have specialized forces, you're organized, you have a policy to do it. That's clear. And this is not an interpretation. The first was an interpretation. I admit this is facts, beyond reasonable doubt. About the abductions, Mr. Heijmans made his report. I want to emphasize that only those where we had 3 different sources we could rely on that we kept. For instance, we had here one of the witnesses who was explaining the socialist work. It was 4 or 5 days kept. We did not take it in the report. His case is not in the report because only the 2 weeks as a criterion was taken in account. It was very sharp. The 95 abductions had to respond to a very sharp criterion. And I think the very nature of these abductions, the fact it is organized, we see planes are organized. We see the way, I think it was just from Westerhuizen who said it's a very weird way that people coming in without passport, they go to the passport control, and we see often they said, okay, you have your passport, we see you arriving here. It is an organized system, it's a policy, the people has to be informed, and for international abductions, we know the government says itself, it is our policy. It is our policy. We will find you everywhere. Even the president was declaring that. And I come to the third part, the judiciary. It's for a lawyer very difficult to say, but we cannot otherwise than say that, sorry, I have forgot here to go through, excuse me. The continuous actions of prosecutors and judges against clear decisions of the European Court in disrespect of basic principles as fair trial, equality of arms, not accepting declarations where torture is claimed without examining first that very clearly makes the judiciary co-responsible. There is, of course, an explication. We see that judges who dare to oppose this way of working or contradicted openly by the government, by the president even, we know that they are removed to other places. We are removed from the judiciary. They are put in jail. Some that is explaining, and it is again confirming the policy of the executive branch, but that does not make it without responsibility. And I come to the conclusion on the existence of the attack. There is an attack, that's my opinion, consisting of a course of conduct involving the multiple commission of acts of torture and forced disappearance, directed against a specific civilian population, pursuant or in furtherance of a policy, promoted and encouraged by different levels of the state. Now, the second stage is this attack existing. The attack must be widespread or systematic. That is the requirement according to customary law and codified by the Rome Statute. I insist it's alternatively, it is widespread or systematic. One of both, to be said, is enough. We will examine both and see what the conclusion is. The qualification, widespread or systematic, is applicable to the attack as a whole, not to each act separately, not to each kind of act. So we do not have to prove that torture is widespread or systematic and that abductions are widespread or systematic. It is the global attack that has to be widespread or systematic. And then, of course, if we go further, which not today, there has to be a proof that each individual act has a nexus to these attacks and that someone is responsible for that, he knew it, he intended, and so on. But to say there is an attack, it is the global action that has to be evaluated, whereby widespread refers to the large-scale nature of the attack and systematic to the organized nature of the acts of violence and the improbability of their random occurrence, as said in the jurisprudence. I give some examples. We had a first one here, which was about a very large territory with thousands of civilians forcibly displaced, hundreds murdered, many raped, was considered as to be widespread. Also, at the third bullet, the village of Bogoro. Why is that important? That's a rather small village, and there were approximately 200 civilians killed. Why it's important? Because they took into account the fact that it's a small village, and these 200 people were nearly whole the village. And they say that's widespread because the impact of the act on that village was very important. And we see that in the second bullet where they say it's not only a neither exclusively quantitative or geographical, but it must be carried out on the basis of these facts. And that is important for our situation. I think that is perhaps determining our conclusion partly. Because what is our conclusion on this for the Turkish situation? First of all, this widespread requirement, if we take the cited example of the ICC, the 3,000 torture cases per year, 95 cases of enforced disappearance, we think this corresponds to what has been said in the ICC jurisprudence. Taking into account also, I must say that, what we have seen is the impact, indirect impact, which the European Court on the family already decided that the sufferance of the close family of the one who is tortured can be seen as torture itself. But I want to emphasize one element, because we have the numbers. We have the number, 3,000 a year torture. But you also have the continuing factor. It's from 2013, let's say, if we follow, and I see why, you don't see why we would not, the analysis of Judge Perilli from 2013 to 2021, it's a continuum story. It's a continuum targeting of people. And that means that no one from the targeted groups can never and nowhere, because we have to do with torture, and we have to do with abductions in Turkey, and we have to do with abductions outside Turkey. So no one of this group can never and nowhere consider himself as safe. So the widespread character has also to do with the impact, who is massive, even global, on this group, and where the government actually also says, and we will go on until we have them all. So the threat is more widespread even than the fact. And that has been testified here already. Someone said we are nowhere safe. So I think that is a quite important element that I would emphasize. The numbers already are high. I feel a bit uncomfortable to say 3,000, but I have to emphasize a bit more, as if 3,000 people who are tortured a year is not enough. But I think it's important, the qualification, to add that. The systematic, we see again in our situation, in our jurisprudence, how it has been. It is a lot of repeat, non-accidental repetition of similar criminal conduct on a regular basis. I will not repeat it all. We already have seen that the evidence demonstrating that preparations for the attack were undertaken in advance and that the attack was planned and coordinated. On that part, I think that the conditions they put here are very close to what we said policy. I explained that under policy. And it's hard not to see that it is systematic also because it's not only a policy, not a policy towards a part of the targeted population, but systematic also wants to say it's a target to hold the population of the targeted groups. And again, until the targeted groups are destroyed, eliminated, eradicated, we will go on. And so that means the systematic element, it doesn't stop. It still continues today. It doesn't stop until this global target group. So my conclusion is in that, that the attack, you can read it, is widespread and systematic. However, we know that crimes against humanity is a very hard accusation. We know that some systems are not longer sufficient. The national systems in Turkey are not sufficient, and we also see that the European Court has huge problems to make the decisions executed. In the case of Kavala, there were already 8 meetings of the Committee of Ministers, were 3 on the Demirtas cases. They are not executed. They do not let the 2 persons in case Kavala and Demirtas free. The existing system doesn't work. But does that mean the ICC, for instance, has a huge task? Is this priority? We know that crimes against humanity, we have the formal legal aspects that they gave, but also a question of what do we take first? Are there no other priorities? Is this a priority? It's something that, even we would not like it, we have to take into account. Is this a priority? Is this a priority? And for that, I will show you a picture. This is Mr. Inandi. He was abducted from Kyrgyzia, and President Erdogan. President Erdogan is giving a press conference with the picture, and he's saying, we got him. We took Inandi through our embassy. We have testimonies from that. We illegally deported him to Turkey, and he's here, and we will catch them all. And even more important is this part of the picture. This man, which you see with his hand, he's holding his arm. I was with someone who immediately said, this man has been tortured. He cannot hold his hand, and his hand is double thick as the rest. There was an interview of Mrs. Vincianci, a forensic doctor, who said, it's clear, they are showing he's tortured. And afterwards, it's clear his arm was broken in 3 places, he needed a surgery, and so on. So what the president was showing here is, we can catch them, we can torture them, and you cannot come against it. It was the show of the power of abductions and torture. And that's why I think, indeed, it is priority. Because what is here targeted? What is the most important? These abductions and tortures and the impunity and the impossibility of the existing system to really stop it are part of a tendency in the international legal order. And that's why the international legal community and the international legal order has to act. It is a tendency that in case of, it's now terrorism, but it can be everything, or so-called terrorism in Turkey, everything is allowed. And you can even show that you will do it, and you can say, no one can harm me. It is the situation that we had with the war crimes before the First and Second World War, who the winner could never be punished. Luckily, we got rid of that, and the war crimes can be prosecuted. We had the tribunals for that. It's now the situation, those states who fight or say they will fight terrorism, whatever the terrorism is that they say, they can do anything without any state or individual responsibility. And I think that is the reason why it is a priority, because it will encourage, and it is already encouraging other countries to do the same, and it creates a complete situation of complete impunity, which exactly the creation of crimes against humanity and the Rome Statute wanted to avoid is challenged now, and that is why, in my opinion, the reaction against these crimes against humanity is priority for the international legal community. Thank you.
Thank you very much, Professor Vande Lanotte. Thank you very much for this very extensive report and the extensive analysis of all the contextual elements for crimes against humanity. You have said, and I think we can all agree with that, that a crime against humanity is a very hard accusation. That's for sure. It's a very, very hard accusation. Maybe it's the most important one in international criminal law. And you also pinpoint that the fact that many cases against Turkey, maybe when the question my colleague will start with that, are not implemented in the Council of Europe. So there is a problem there of implementation, of execution of many judgments of the European Court of Human Rights concerning Turkey. So the question you put to this tribunal in your report is, do we need, and I insist on need, do we need to qualify the act of torture and abduction, because they are the two main acts, of course, as described in the report, and we discussed that the whole week, as crime against humanity, according to the Rome Statute. I agree, despite the fact that, and you have recalled that, Turkey is not part of the Rome Statute, so that's for sure. So do we need, in the light of what I just have said? My second question, and they are related, my second question, sorry to say that, but in your opinion, what would be the reaction and the defense of Turkey against the allegation that crime against humanity are taking place? So in order to see the other side of the situation. And my third question is the following one. If there are crimes against humanity in Turkey, do you see any other ways to accountability for the perpetrators? Universal jurisdiction, other state, not ICC, because they are not part of the ICC. So that's my question for the time being.
I didn't have the first question.
The first question is just that you recall that crime against humanity is a very hard accusation. That there are many problems in the Council of Europe for the implementation of the judgment against Turkey. So do we need, because that's exactly the word you use, you note in page 385 of your report, do we need, that's the question you put to us, do we need to qualify the acts of torture and abduction as crime against humanity according to the Rome Statute?
Okay,
well,
thank
that's
you very
my
much,
three questions. Yeah.
Madam President. I think, yes, we need, because at what I explained, the classical ways of handling this, national courts, international courts, the execution of the decision of international courts like European, the UN Committee on Human Rights, they all failed. They decided. The UN Committee made a view where it decided the persons abducted should be released. The European Court made statements, made decisions that anti-terror law is not complying and the application anyhow is not compliant, that people should be released. It didn't work. The Committee of Ministers is insisting it doesn't work. And we see that the international community for the moment does not react. States do not react, whatever reason. So why do we need that? Because it is important that some reaction comes, and without clearly defining what it is, because we're not inventing it. It is a hard accusation. As I said, we only started after 1 year of examining all the facts to say we have to challenge that. If we do not, we would not doing what we need to do. And I really think we need to do that. The defense of the Kurdish, of the excuse me very much, the Turkish government, how can I be, I'm sorry. The defense of the Turkish government will be, first of all, that torture doesn't happen. Doesn't happen. They will say that again. I think it is evidence, but they will say, oh, the judges have decided and they are independent. We heard different, that's what they will say. And I think also they will say it's not widespread. There is not 100,000 people who are killed. They will minimize it, I think, because legally it will be very difficult to say that is not. They will say, listen, there are a lot of problems in the world. Is that now the first problem in the world? That is the main difference. That's always the case. Nothing is important until it is important. And that's why I want to emphasize, if the international legal community does not react, this is not the last case. It will go on. We already saw it in different places. It is a license for states to operate again without international control. Because the objective systems that say, state, you have a violation of human rights, you should repair it, which was the organization we had, in the thinking that if a state was condemned by the European Court, they would follow, but that doesn't happen anymore. And that's a very changing situation, but they will minimize, that I'm sure. They will minimize. I think that's the way. The other ways, you have the national courts outside Turkey, and there are some procedures going on, but that's very, very meticulous, very specific. And of course, the judges in Turkey could do it themselves, but yeah, we know that that doesn't work. You have non-judicial actions like the Magnitsky Act, for instance, who could be activated. So there are elements, but that's why a clear, and I think that the legal description I made, I think, is solid. We wouldn't have done it. I'm not intending to say something that afterwards you can be killed for, or not killed literally, but that I say it's a stupid reasoning. But we have a strong, solid case, but the importance must be emphasized. And there are other things. And as long as we do not have the case clearly defined, Magnitsky Act's application will need that. And I hope they can build on that.
To put some question to our expert rapporteur. You? Okay, let's do it. Oh, pardon.
Thank you. I am not an expert on the concept of the crime against humanity. Two short questions. With regard to the civilian population, I take your point that it cannot just be a range of individuals, etc. And I apologize if I missed something in your report and your presentation. But does one have to be able to identify the specific part of the civilian population? For example, Kurds, for example, members of the Gulen movement, but we heard in evidence when someone was asked, what does it mean when you say you're a member? He said, it simply means that I believe in good things. I don't have a membership card, I don't pay membership fees. So should one be able to identify accurately and clearly Kurds, the members of a movement, the members of a political party, the PKK, or just perceived opponents of the government? That is my first question. And the second one, I think, relates to the question asked by the President. In your view, and I'm sorry again if I missed something, should this tribunal, what should be the terminology? If we generally agree with you, should this tribunal make a finding that it is a crime against humanity, or decide that it is a decision, or declare that it is, or simply express an opinion that it could well be, or that the essential elements are there, and then leave it to other bodies, perhaps with more specific, focused authority to take it further. Thank you very much.
Can I get the PowerPoint back, please? Because to answer the question, I will start with the second question. If you can put the PowerPoint back, that would be helpful. Yes, it will take a bit of time. Wait. Okay. Yes. To your second question, actually, a tribunal, People's Tribunal cannot say a crime has been committed. The crime means you have an author, you have a fact, and you have the link between who is a criminal link. We cannot say that. What I wanted to explain is that the facts, strong violation of human rights, namely torture and enforced disappearance, do meet the legal requirements, contextual elements. I said it between brackets because the contextual elements is only in the Rome Statute, while the legal requirements is for the general system, to meet the legal requirements needed to be considered as crimes against humanity. That is what I think is the conclusion that I made and that I bring forward to you. I do not say, you cannot go further, that's clear, but this is the most important. But this allows now to see if the contextual elements as a prerequisite are there, then you can see who is responsible, do they have jurisdiction, and this and this and that. That's so. I hope with that I responded to the second question. For your first question, I will try to go here. Yes, in the definition here given, groups distinguishable, but they say here a group defined by its perceived political affiliation. And the term perceived is important. We do not have to prove that everyone who was targeted is a member, how difficult it could be, of or Gulen movement, for instance, or the PKK, of something else, but they are perceived by the government as such, for instance, because they use the Asia Bank and the bylocked system, and they are perceived by them, and that's why they were targeted. That's what has to be defined. And we do not need to give clearly the definition, because indeed, as you said, it is not possible.
Sorry, but here there may be more than one perceived political affiliation.
Yes. And we can say, you can have, it's a double system, which makes it even worse, of course. But it has not to be, it is, the civil population can be more than one group. And they have one thing in common, that they are, since 2013 actually, they have in common that they are in kind of an opposition, one way or another, to the government. But that's not the main element. They belong to that group, they were targeted, and they were...
Then it goes quite wide, because then it would mean perceived to be politically opposed to the incumbent government.
It is like that, but it is in one of these cases, for instance, it was clear that they say this group, because our ethnicity, are seen as they will not vote, and so, without saying that they voted or not, they were attacked, and that was considered as an attack against the civilian population, indeed.
Thank you very much. Now I will turn to John, to Justice Spaces. Do you have any question? You have the floor if you need.
I do, but first of all, thank you very much, Professor. That was a very impressive and inspiring presentation. I appreciate the dynamics involved that are necessary in order to characterize the situation we are examining as spinning off elements of crimes against humanity. My question is more geared to the potential follow-up. Assuming that the evidence shows a consistent pattern, a policy, if you like, but certainly a practice which would contain all the elements requisite to conform to a crime against humanity. And given the fact that the country concerned is not a state party to the Rome Statute, but maybe this tribunal will need to undertake very serious reflections on if it finds that there are those elements, which way the tribunal would suggest that the focus goes, admitting that we have agreed that there is a need to amplify focus, because if anything, the existing international, and forget the local mechanisms, have been tried and tested, and the situation has not been affected at all on that assumption. So do you have any ideas or views or vision as to how and in what formal context, if possible, would the next area, the next step be, in your view?
Yes. There are several ones. First of all, the qualification as crimes against humanity means that every national court has a larger jurisdiction than towards ordinary crime. For the national jurisdictions, the conditions to persecute a crime against humanity, as far as prescription, for instance, is concerned, but also as far as the conditions of presence on the territory of the victim and the perpetrator, are not the same. They differ for each country a bit, but there are broader possibilities for the national courts, and we already see that some preparations are made here and there, but it's difficult. And most countries have had experiences with universal jurisdiction and have come back a bit from that because of difficult experiences. But that's the first, the national court. The second element is that the ICC, the Rome Statute, has not been approved by Turkey. That's right, it's not ratified. However, and it's still a bit in a preliminary phase, but the situation of the Rohingya, where the Myanmar, the expelling country, if I can say, is not ratified the statute. However, the receiving country, it's Bangladesh, I think, has ratified. The ICC has said, as this crime continues to be committed in Bangladesh, we have competence, we have jurisdiction. That means for these international abductions who start from a country that has ratified the Rome Statute, the ICC has jurisdiction. And there are 11. There are 11 abductions from countries which have ratified the ICC. So we can try. The whole attack is Turkey and all the rest. But these 11 are following in the jurisdiction, and we cannot deny that. That's the second. The third element, as I said, when you have crimes against humanity, is an element in all the Magnitsky Act, United States, UK, Europe, is a determining factor, determinating factor to say, listen, if that occurs, we can activate that Magnitsky Act. As you know, the Magnitsky Act makes a possibility to limit people traveling and to freeze some assets. So I think, yes, we have a follow-up at the national level, possible. We have a lot of work still has to be done, a possibility at the ICC level, and there is a possibility at the Magnitsky level. And I must say you, after 2 years' work and knowing what happened this week, we will not stop.
Thank you very much. Thank you for this. As you said, Justice Verce, very inspiring intervention on a very difficult subject matter, crime against humanity. Okay, thank you very much. So, voila, the morning is over. We will meet each other this afternoon at 2 for the video on the subjects we've been hearing all week. Voila, exactly. So we meet at 2. Is it okay? Is it not too short time? Okay. A small lunch, okay? A quick lunch, and then we meet it at 2 for the video, and then I will say something about the deliberation and the last meeting on Friday. So we meet at 2, and thank you very much for your presence here. Qu'est-ce qu'il est brillant. Il est
It's, oui, je tiens.